Hello everyone, my name is Elham Moaveni of Moaveni Law Firm, and this is Legal Rights, only on CIB24.com. Our goal is to address legal matters and answer your questions. On what basis can a judge take custody from a parent? This question deals with family issues and usually is dealt with in family courts. Generally, you must know that a judge does not take away a parent's right for custody of a child. Instead, a judge makes a decision, the best decision for the best interests of children that are involved. And so generally what they try to do is to maintain the status quo of the family. So for example, if the children are generally stay at home with mom, they generally try to keep the children at home with mom until the matrimonial affairs are dealt with, and or vice versa. If mom is a working mom and the children are generally taken care of by the father, then the children would stay with the father and be taken care of by the father until, again, a final decision is made on what is in the best interest of the child. And of course, the court relies on the opinions of various professionals, such as a children's lawyer, and those are appointed by the court, generally called the OCL, or the Ontario Children Lawyer. And these people would come and assess and make an opinion about what is in the best interest of a child, and social workers and teachers, and there are obviously other people that may contribute to the decision making of a judge. If my partner wants a divorce and I don't, is there anything I can do to stop it? In Ontario, divorce is a unilateral decision. So if one party to a marriage wishes to be divorced, then the other really has no right to stop the divorce. In different countries, obviously, that's different. But so perhaps if, let's say, the husband seeks a divorce, then really he relies on the law of separation or violence or adultery to seek a divorce, and it's likely that he would get it. And of course, if there's children, this would either lengthen the time or shorten the time, but you have really no choice. What if I have been arrested and the police tell me to tell them what happened? Should I? It's very likely that the police would be very friendly at the outset and ask you to tell the story. And it's very likely that having been invited to tell the story, you would want to tell it. Except that you have to be very careful, because often people who are in the presence or detention of a police may say too much, or may say things that they weren't supposed to say. So my recommendation would be to not say anything until you speak to counsel. And remember that counsel at the police station is available to you, and the police will explain that to you and say, you have a right to counsel. Would you like to speak to someone now? And they'll provide you with a phone and a private room, and you'll be able to contact a lawyer, someone who's on duty or somebody that you might know, and you can ask them, should I tell them what happened? And very often the counsel will say, don't say a single thing, let me speak to the police myself. And so really it's important that you exercise that right. If I cannot afford a lawyer and one is provided for me, will my quality of representation suffer? It's my opinion that anyone who has a case in court should be represented by counsel. And remember, it's always better to be represented by counsel than to be self-represented. Here's your tip of the week. Use common sense. Do not let your emotions control any issues that affect your day. Exercise logic before saying or doing anything you may ultimately regret. Thank you for joining us in this week's episode of Legal Rights, only on CIB24.com. If there are any questions you'd like answered, please send them to info@moavenilaw.com. I'm Elham Moaveni, and stay out of trouble.